Hi friends, this is CS Apurva. Today we are going to discuss the Model Tenancy Act, which was recently approved by the central government on 2nd of June 2021 for circulation to all states and union territories for adoption. Since land and property are subjects of state list, hence states can adopt this act via a fresh legislation or by amending their existing act which regulate tenancy or rental housing laws. Why the need for Model Tenancy Act? The growing pace in urbanization and migration of people from rural areas to urban cities for jobs, better education, and other reasons is creating an issue of huge housing shortage. This act aims to address this issue of huge housing shortage. Further, through this act, the central government aims to institutionalize the rental housing market and gradually bring rental housing into formal market. It also seeks to protect the rights and interests of both tenant and landlord. This act aims to bring more transparency in rental or tenancy laws. This act makes it mandatory to execute tenancy through a written agreement, and both tenant and landlord will be entitled to any relief under this act only if a written agreement between landlord and tenant is made. This written agreement has to be compulsorily submitted to a rental authority, and on the basis of information submitted, the rental authority shall give an unique identification number to the concerned parties. For each jurisdiction, a rental authority shall be appointed, who shall be a person not below the rank of deputy collector. In case of any dispute between landlord and tenant, they shall first approach the rental authority, who will pass an order resolving their dispute. If any party is unsatisfied with the order of rental authority, he or she shall move to rental court by filing an application against the order of rental authority. The Act protects the rights of the tenants. We have seen that in cities, especially urban cities like Mumbai, Bangalore, the landlords have exploited the tenants due to lack of proper tenancy laws. They have charged from tenants very high security deposit. So in certain cases, security deposit even for 1 year. This act puts a cap on the amount of security deposit that can be taken by the landlord from the tenant. In case of residential premises, it shall not be more than 2 months. In case of commercial premises, it shall be restricted up to 6 months. Further, the landlord shall not withhold essential supply or services to the tenant's premises. If the landlord does so, then on a complaint being made by the tenant, the rental authority will do proper inquiry, and on inquiry if it is found that essential services were withheld, in that case it may award a compensation not exceeding 2 months' rent to the tenant to make good for any losses suffered. However, if it is found that the tenant made a false complaint, then the rental authority will impose penalty on the tenant. This act also prohibits a landlord from entering the tenant's premises before sunrise and after sunset. A 24-hour prior written notice has to be given to the tenant in order to enter the premises. This provision shall not be applicable where there is an emergency situation like flood, fire, or any other natural calamity that affects the premises. The Act gives certain rights to the landlord under the Model Tenancy Act. Under the Act, the tenant shall not make any structural changes or alterations in the rented premises without the written approval of the landlord. Also, where the tenant fails to pay rent and there is an arrear of rent, the landlord shall serve a written notice to the tenant to make good the default in rental payments. If the tenant fails to make payment for 2 consecutive months along with interest within 1 month from the date of notice served, in that case, the Act allows the landlord to make an application to rental court for eviction and recovery of premises. Moreover, where the tenant does not vacate the premises as per the terms of agreement or on expiry of tenancy agreement, then the tenant shall be liable to pay the landlord 2 times the monthly rent for 2 months and 4 times the monthly rent thereafter till the tenant does not vacate the said rented premises. Further, the Act allows landlord to charge from the tenant for any damages caused to the rented premises due to misuse of the rented premises by the tenant. Unless something is specifically mentioned in the Act, the landlord will be responsible for structural repairs. This shall not be applicable where tenant has caused the damage. Where tenant has caused the damage, the expense will be borne by the tenant, and the tenant will be responsible for periodic repairs, the repairs that are caused due to normal wear and tear, like changing of taps, washers, drain cleaning, etc. The Act provides for establishment of a separate court named the Rental Court and the Rental Tribunal for fast-track redressal of tenancy-related grievances. This court shall have the same powers that a civil court has, and all the proceedings before this court shall be considered as judicial proceedings. The Model Tenancy Act has many progressive provisions which will give necessary boost to the private sector to develop the housing projects in build to rent model. Further, this act will help in fulfilling the India's rental housing potential.